last year was filed Dreyer versus NFL Films, and I think it was about a month or so ago that a settlement offer came in from the NFL, and it was presented, and we posted it up on Dave's blog. It was, what, 50, 60 pages long, I think. So for those of you who haven't seen it, what we've decided to do this year was we had actually invited attorney Dan Gustafson from the side that was putting out the settlement on behalf of some of the players, along with Ron Mix, who's going to talk about the settlement offer. And then on the other side was Mike Ciresi from Robins, Kaplan, Miller, Ciresi, and Fred Dreyer, who was the original plaintiff on the suit. So we're going to have both sides presented to you guys so that you can make some informed decisions about this as it moves through the process. Shortly, they're going to be trying to reach out to every one of the players that are in the class. So you'll be able to also voice any objections or opt in, opt out of the lawsuit. That's how class action lawsuits work. Unfortunately, at the last minute, I got notification that Dan Gustafson had a family emergency, an illness or something in the family, and he couldn't make it. So Ron's going to be here at least to talk on their behalf about the pros of the settlement offer, and then we'll end up with Mike Ciresi and Fred Dreyer also talking about it on why they feel that the offer is not good enough, or not what they want. With that, I'll just open the floor up to Ron. You folks can actually take the podium if you want, to make your own presentation first, and then sit down, and we'll answer questions directly from the audience after, hopefully.
Robert, I can't see my notes from the podium.
Oh, okay, that's fine. Sitting down's fine too.
But let me ask you, Dan's office was going to forward to you a PowerPoint presentation. Did you get it?
Haven't gotten it yet.
They did send to me a bunch of copies. Let me give Fred and Mike one, and maybe you could pass it out to everybody so that when I cover it, they'll be able to have something to look at.
We'll do that. If you could, in fact, if you've actually got a copy of it, Ron, email it to me, and I'll put it up on the screen for everybody to see. So if you have a copy of it.
I don't.
Okay, not a problem. Thanks.
Oops, here's some more. Okay. Thank you. Well, while that's being passed out, let me just make some preliminary remarks. Dan Gustafson, let me just tell you who he is. He had a family emergency, first of all, and he couldn't be here. He wanted to be here. And he was appointed by the federal court to be what was called the lead settlement counsel, And he was appointed that because at the time there existed 3 attorneys who were identified by the court as the lead plaintiffs counsel, and that was Bob Stein and Michael Hausfeld and Charles Bucky Zimmerman. And the 3 of them were in a major dispute as to how the litigation should go forward and whether or not there should be a settlement, and if so, for how much. The judges felt that that this dispute was, first of all, was something they said they'd never really experienced before, where lead counsel could not agree on a common course of action. So they felt that the process was being compromised, not blaming either side, but just saying the process was being compromised, and settlement negotiations could not be fruitful. And so the judges decided to appoint Dan Gustafson, who was a well-known, prominent class action attorney in the Minnesota area. So they appointed him as the settlement attorney. Dan undertook an effort to resolve the claim. He had numerous meetings, I understand, with both parties and numerous meetings with the judges. He was able to make some, what I think was significant progress. He was not able to increase the $50 million offer. However, he was able to improve upon it in this respect. The $50 million originally, I believe, was offered by the NFL to be paid out over a period of 12 years. I could be wrong, but that's just my recollection. And he was able to get them to reduce it to 8 years. The original $50 million offer included two things. By the way, excuse me, I want to be coughing now and then, and when I'm giving you, to many of you, a glimpse into the future, that when you get 30 pounds overweight and you get acid reflux and the medicine doesn't work, you might have a cough. That doesn't bother me, but it's got to be irritating for you to listen to. But in any event, the $50 million was to be divided into two agencies, essentially, two corporations. A not-for-profit corporation called the Common Good Fund, $42 million was to go into that, and a licensing agency, $8 million was to be available for a combination of things. One, setting up the licensing agency, and two, to pay attorney fees and costs. The goal of our group, who, and I'll get into it later, who are on the board of directors, of course, is to keep those attorney fees as low as possible, because we want to see the licensing agency adequately funded. The licensing agency is a arm that will then, with the cooperation and promotional power of the NFL, promote group licensing, try to get opportunities, earning opportunities for those who participate in group licensing. And the idea is that monies derived from that, 75% will go to the group who are part of that particular licensing. For instance, let's just say that the 1963 Bears, I think that was the year they had their championship year and great defense and everything. Maybe they're going to be featured in something. Maybe they all get together and there can be an earning opportunity. So there would be 75% of whatever money was available would go to them, and 25% would go to the Common Good Fund after there's a deduction of approximately 15% for the operating expenses of the licensing agency. Now, the concept of the of the licensing agency is that, one, it'll earn money for retired players as individuals, and two, that monies will be available to hopefully fund the Common Good Fund in perpetuity, so that it's something always there to benefit retired players in a whole variety of ways that we'll get into a little later. But in any event, Dan was going to give you a presentation on why he was appointed, his role, the type of negotiations that took place, and why he ultimately decided that the settlement is fair and reasonable. And he was going to have a slide presentation that's depicted in this hard copy that I've given you. I won't get into what would have been the slide presentation now. I will get into it a little later, but first I wanted to give some initial comments. Now, just to reiterate a bit about what Robert said, this litigation, as I'm sure you know, those of you who follow Dave Pear's blog, it arose out of retired players asserting that the NFL and the NFL films used their images without consent after they retired, and that violated their right of publicity. The NFL denied that the use was wrongful. They said that the consent was by the player's contract, and I think they also said it was by in the collective bargaining agreement. Further, they said there was no objection. The consent was almost assumed because there's been no objection for the 50 years that NFL films have been using our likenesses. And they also said, the defense, that the public right to be informed about the history of the game makes it something that is protected under the First Amendment. And they finally said that these images were never used to endorse goods or services. So there came a point when there was a tentative approval by the judges who were in charge of the case, Judge Magnuson, and he tentatively approved it, and we'll get more into that a little bit later. Now, the entire history of this dispute, and as to whether or not it is a good or bad settlement, is really too long for me to get into, and candidly, I really have no intimate knowledge of it. Suffice it to say that from a timeline standpoint, just very broad strokes, originally this was Bob Stein's idea. Bob was a former Los Angeles Ram, Kansas City player, and it was his idea, and he brought in Fred Dreyer, Ed White, Elvin Bethea, and 3 others to be what are called the original plaintiffs' representatives. They represent the class. The class is you, it's us, it's me, and there's over 20,000 of us. And at some point, the original 6 expanded to, and I think it was before there were any friction between anybody, expanded to 9, and 3 additional players were added as plaintiffs' representatives, and I believe it was on the basis of getting more diversity, bringing some youth in to make the group of plaintiffs' representatives more representative of the entire body of this 20,000 or so. And so Fred Barnett and Tracy Simeon and Darrell Thompson were added. Then at some point, this dispute arose, and a new group of plaintiffs were brought in. It's my understanding, again, I wasn't there, but it's my understanding that the court wanted proof that there were more people interested in supporting the settlement, and wanted more people added to the plaintiffs as plaintiffs' representatives and as class representatives. And so eventually a whole bunch of others were added. There was it included the original 6, and it included the 3 who were later added who wanted to support the settlement, and a large group of others who wanted to support the settlement. And then, of course, this major dispute, Dan Gustafson being appointed. Now, the additional people who were added, I'm going to give you their names, because you got to put names on this so you can appreciate it. Jim Brown, Lem Barney, Mark Clayton, Irv Cross, Brian Duncan, Billy Joe Dupree, Mike Haynes, who is here today, Paul Krause, Bruce Laird, Reggie McKenzie, Preston Pearson, Reggie Rucker, Jackie Smith, and Jim Ray Smith. So all of those now make up what are known as the class of representatives. Now, my role, I am not a class representative. At some point, the court wanted a board of directors appointed to run these organizations, and I agreed to serve on the board. And I'm on the board now of actually 3 organizations that we've formed. We formed the Pro Football Retired Players Association, which will really run both of the organizations, the Common Good Fund and the licensing agency. At this point, it's one board of directors because everything is just still in its formative stage. And the board of directors is Jim Brown, Irv Cross, Billy Joe Dupree, Dave Robinson, Darrell Thompson, Jack Youngblood, and me. Now, that's the board of directors presently. However, it's our intention to add some high-level, sophisticated marketing businessmen and women to the board. We fancy ourselves, we don't pretend to be sophisticated business people, although most of the board are professional people in one form or another, but we don't pretend to have the knowledge to really operate a licensing agency properly. We see ourselves as the conscience of the group, that we want to identify the need areas for retired players, and we want to implement the programs, but we need some top-level business people to help us make this thing work. The class representatives, they've got one duty, and that's to do what's in the best interest of the class. I completely believe that both the proponents of this settlement agreement and the opponents of the settlement agreement in their mind, have the best interest of the class. They're acting in the best interest of their class and their belief, not for something that they may gain. Now, I've been active on player rights things for, wow, 50 years. I was one of the original founders of the American Football League's Players Union. I was vice president of that group for many years. I was a player rep with the NFLPA. I became president of the retired players section of the NFLPA in the mid-'80s. Had a complete falling out with the NFLPA because I thought they were not expanding benefits to retired players when it was in their power to do so. I found it was just impossible at that point to do anything for retired players as a group, so I decided to focus on a smaller group that had problems. I was inducted in the Pro Football Hall of Fame in 1979, and one of my shocks upon being inducted was to find that how many of the Hall members were living close to poverty. We had something like 18 Hall members living on nothing more than that paltry then NFL pension and Social Security. People somehow getting by, perhaps not getting by, on $20,000 or less a year. We had 2 members living in trailers. So in any event, I formed the Hall of Fame Players Association, was president of that group for many years. Without getting into great detail, I would just tell you that we were able to develop enough products and enough events that we were able to fund a charitable foundation. And I can tell you now that there is not a single Hall member or wife of a deceased Hall member that is living anywhere near close to poverty level. We just don't deny it. We won't allow it. In all that time of being active on things, frankly, I've never seen such a divisive issue as the one that we're faced with today in the image rights, those for and those against. Of course, we're in the high communication age, and there are blog writers and putting out their opinion, and they feel very strongly about their opinions. They've leveled personal attacks on the lawyers who want to settle. They've leveled personal attacks on Judge Magnuson, the respected judge in Minnesota. They say he's selling out to avoid a trial. That's why he's recommending a settlement. Oh, please. This is a respected, experienced judge in Minnesota. Would risk his reputation on if he didn't promoting something he didn't believe in. I mean, look, if you're a judge, your dream is to have a high-profile trial, and nothing will be more high-profile than this. Don't you believe Judge Ito was thrilled to be able to preside over the O.J. trial? It's just ridiculous to say that about Judge Magnuson. There's been personal attacks on Dan Gustafson. He was just a guy who was brought in to try to help things out, and personal attacks on him. It seems like the personal attacks are, they feel that everybody who's on the pro-settlement side side has got some sort of motive, and it's an unhealthy motive as to why they're pro-settlement. I mean, recently, Jeff Nixon attacked the board that I just identified, and attacked me and suggested we have something to gain by serving on this board. Now, I really get it. We're football players. We're aggressive. We're used to attacking when we want to make some progress. I don't know if any remember, but about 40 years ago, the scientists discovered this XX chromosome in overly aggressive men. It was predominantly found to exist in criminals and pro football players. So I understand that. That's the way we react. But you know, it doesn't make it right. I mean, let's just go back and look at some of those. Let's look at some of those people I mentioned. I mean, who are being disparaged. Jim Brown. I mean, he was part of the civil rights movement, both in football and out of football. He runs an organization for many years called The Mayor I Can, where he's trying to assist kids who are involved in gangs and try to get them out of gangs. Reggie Rucker, that's one of the names. He runs Jim's organization for him. Have you ever heard anything wrong about Irv Cross, Billy Joe Dupree? What about Bruce Laird? He's been at the forefront of players' rights movements for years, one of the leading voices. Bruce Laird, Tony Davis, I'll just tell you, Tony Davis spoke to me, and he's been one of the leading voices for players' rights, and Tony agrees with the settlement. And, you know, added to that is Dave Pear and Robert. They've been leading advocates. They take the other position. But we don't say there's anything wrong with their motives. They just believe differently. Now, let me tell you why I believe the settlement is reasonable. And let me tell you why I know that there's certain people, that there's tangible proof that certain people on both sides are acting 100% in good faith. If there is anybody on the opponent side to this settlement who may have a viable claim, at least someone, if they can get past proving liability, can prove damages, it's Fred Dreyer. He's willing to give up his claim on behalf of advocating a settlement for all retired players. If there's anybody who would have a viable damage claim, if you're be able to get past the liability stage, it's Jim Brown. He's willing. He probably has the largest claim of anybody. He's considered the greatest football player in history. He's willing to give that up in order to get a settlement that would benefit all the players. Now, also, let me just dispel something. There seems to be, on some of the bloggers and some of the people who respond to the blog, they seem to indicate that those of us who support the settlement are on the side of the NFL. It's just not true. I fight the NFL every day in my law practice. I mean, absolutely every day. You were here yesterday. I'm sure you heard me say some very unkind things about the NFL and the position that they're taking in trying to eliminate out-of-state players from filing claims in California for workers' compensation. I'm going to tell you my reasons and for supporting it. And when I do, keep something in mind. Those of you who were here yesterday, and Michael, your partner, Mr. Hazard, did a great job yesterday.
Well, I didn't know that.
He probably told you he did.
We had dinner last night, he did.
He did, I knew it. But at any rate, it was a primer on image rights. And keep in mind some things as I talk to you about it. Keep in mind that, one, he told you it was a state-created right, whether by common law or statutory right or both. It's a state created right. And he told you that in order to establish a claim, you need to prove that a defendant used your image unlawfully, that the defendant used the image to, the defendant used the image to their advantage, that it was done with a lack of consent, and there was a resulting injury. And I hope I'm not misquoting you, Mr. Hazard, but I think he also indicated that these image right cases are difficult cases if it's something other than where somebody, it can be proven that somebody used your image to promote or endorse a particular product. So if you keep that in mind. Now, the reason that I support a settlement is just one other thing about my background. Prior to doing workers' comp, I was in civil litigation. We thought we had a pretty sophisticated business litigation, personal injury litigation practice, and it included class action work. I was never a lead attorney on a class action. I don't profess to be an expert in the area. I do have some residual knowledge because I did work on some of the cases. To me, there's a major risk that if this moved forward, the class would get nothing, absolutely nothing. And that the first step would be you have to have the class certified by the court that it is a class action. Based on what I've seen in the law, based on what I know about our members, about myself, I don't think the class would be certified. Another important thing is damages. In order to certify a class, the retired players would have to convince the judge that it would be manageable to be able to determine every single unauthorized use during the class period. Which players are in the use, which ones are entitled to recover, what amount. I mean, that means reviewing hundreds, maybe thousands of NFL films, and to try to determine which players were featured in the NFL film, which showed up only as bit players, how long they were on the field, because you can only recover damages also, and this has already been determined by the court, for a limited period of time. The court has already determined, and this is the law of the case right now, the court's already determined that you will not be able to recover for 50 years of their unauthorized use. And by the way, I think their use was unauthorized, but you would not be able to recover for 50 years. You can only recover for 6 years before the claim was filed. So it was filed, I think, 2009. So you can only go back to 2003 to recover damages. That would limit significantly not only the damages, but it would limit significantly those who'd be able to collect. It would probably eliminate a lot of people. Now, there was our making this class action suit isn't the first time the courts have been met with it. The Major League retired players tried this against Major League Baseball. In the Seymour Block case versus Major League Baseball, the court did not certify the class. It was almost the exact same thing as what we're doing. The court did not certify the class. And let me tell you what they said. They said that some of the proposed class were Hall of Fame players, others were virtually unknown, and that this variation and the consequent difficulty in proving claims and calculating damages for individual class members required denial of certification. Mr. Hazard told you about a Major League Baseball case yesterday, Gianfredo. So that stemmed from the Block case. So the class was denied, and when the class is denied, then the individuals can bring their own claim if they feel they have one. And that's what, if the class were denied in our suit, then those who felt they had a claim could bring it as individuals. And 4 members There's no way that I would ever bring a claim because I feel I benefited from it, even though I concede that in many instances it was unauthorized. Not all of them. In many instances, I did authorize it. So, without class certification, you each have to bring your own case. You know what that would apply to? I think to 99.5% of us. And good luck to us getting an attorney to take the case when it'd be so difficult to prove. I mean, each individual case, litigation is expensive. You got to take depositions. You got to filing fees. You got to bring in experts. You got to do discovery. I think only the major stars. I don't mean just Hall of Fame players. 90% of us in the Hall of Fame would not have a claim because we'd be unable to establish that we've ever earned any money. We couldn't establish for our use of our image. We couldn't establish what Freddie Dreyer could establish, Jim Brown could establish, Irv Cross could establish. We wouldn't be able to do it. Now, if the class action is denied, and if there are appeals, or if the settlement goes through and there are appeals of it, it could take forever in the court system. Some of you might be familiar with the Central Park Five. These are 5 African-American teenagers who were wrongfully convicted of rape, and they spent 20 years in prison, and they were exonerated through DNA, I believe, and they then properly brought a lawsuit against the city of New York. They brought that lawsuit 10 years ago. It still hasn't resolved. It's still in the appeal process. And during this time, during the endless time of appeals that could take place in a case like this, the many retired players that would have benefited from this settlement would go wanting to their death. Now, Judge Magnuson, he questioned whether people could, the vast majority of us could, Judge Magnuson questioned whether the vast majority of us could approve damages. And from what I've seen of the case, the cases, that would be a problem. Here's the things that I felt that I could not consider when trying to decide whether I support or oppose the settlement. I couldn't consider the value of the film library, the NFL films. I've never seen anything in any cases that suggests that that would be consideration of the damages. I couldn't consider the benefit to the NFL, only because for me, and I think 99% of us, I don't know how we could prove that we had that our use of our images benefit the NFL. I couldn't consider the size of the settlement. So what? I think it's a bargain to the NFL. A bargain because it doesn't cost them much if you figure it out on an annual basis, and they get to buy their piece. And yet, I can't consider that. I can only consider the value to us and what it means to us. I couldn't consider, you have to consider, could you have held out for more? Could you receive more? I don't think so. It's not like this suit was just filed and suddenly it settles and there was no time to do discovery and no time to take place in negotiations. It's been going on for 4 years. And the most important hearing in the case isn't the trial. It's a hearing to determine whether there's certification. And if it's not certified, then I think everybody loses. Now, it's said that $50 million is too low. Well, what would be better? Would 200 million be the right number? Now, if it were 200 million, what would that do for the class? Remember, we got over 20,000 in our class because the class is made up of anybody who was ever active for an NFL game. 20 million, and do you think it would be divided equally? If that's not the way it's done. If it were divided equally, then each person of the 20,000 would get $10,000. It wouldn't be divided equally. That's not the way it's determined. It's determined on what your individual damages are. And do you think, many of us know the higher profile guys and think they're great guys. Do you think that they're going to say, let's divide everything equally? Can you count on that? I don't think so. I think they'd want their fair share. I mean, because the fact is, on these NFL films, they weren't the bit players. We were. They were not the bit players. An illustration by some of the bloggers that this is unfair is they say that the Common Good Fund only nets $42 million, and that's nothing. And they use a math illustration saying that it amounts to, if it's spread out, it amounts to just a few $100s to each person. That's the wrong analysis. The right analysis is what good can you accomplish with the $42 million? With, I hope we have $2 million to fund the licensing agency. What good can you accomplish? For instance, this is not a reach. There's 20 million people that have been diagnosed with cancer in the United States. And if somebody wanted to make $50 million available to them, you could laugh at that and say, hey, that's only, what, $2.50 a person? That's ridiculous. Well, is it? What if it was $50 million that would be given to a research center that could benefit the greater good? It doesn't become so ridiculous anymore. Now, we're able to provide, and I'll get into what would have been the PowerPoint presentation when I talk a little more specifically about what Dan would have told you, but the Common Good Fund covers a lot of different areas that we can use the money to cover the health and financial difficulties of athletes. But it's not limited to some of the examples that you're going to see in the PowerPoint presentation. This is run by the board of directors. We're independent of the NFL. We're independent of the Players Association, and we can come up with our own programs. I hope to sell our group on the program of providing educational grants for players and children of players. I mean, just for an example, there's be approximately $4 million a year to distribute. That would amount to 400 educational grants of $10,000 each. I mean, that's something you could do for the common good. How many of us would benefit from this? Maybe none of us would, but we still would be doing something for the common good. Yep. Going too far? Very briefly, I'll cover the PowerPoints. Did you get it? How did that happen? Well, let's go to page 1. Okay, you can read that, but let me fill in. It says the NFL contribute $42 million to Common Good Fund over an 8-year period, but it doesn't indicate there. But let me tell you, it is subject to what's called a clawback provision. And the clawback provision of the $42 million, the NFL, any class member who wishes to opt out and sue the NFL on their own, the NFL naturally is going to have expenses. They want to be able to charge up to $13.5 million of those expenses against the $42 million. Now, the agreement provides they cannot do that until years 6, 7, and 8. So the first 5 years, it'll absolutely guaranteed to be funded by the little over more of $4 million a year. Dan Gustafson was able to get that reduced. I think that was 100% clawback, but he was able to get it reduced to 13.5. the funds are, where are we? Yeah, we are. Well, in any event, I've already told you about how it's going to be operated. So let's move on to the next one. We see how the board, what it can allocate funds for. You see those various things: medical research, short and long-term housing facilities. You see that. But again, our board of directors can decide what are the best programs. I hope to convince them of doing some of it in educational grants. Let me tell you why one of them is particularly important, where it says medical costs not covered under a health insurance policy. Not everything's covered under the health insurance policy. Example, my wife has horrific migraines. The only thing that keeps it in check is this certain medication. It's kept it in check for like about 8 years. Insurance company says the drug is still experimental, so they won't pay for it, and so it costs us probably an average of $600–700 a month. So that's a very important benefit that we'd be able to do. Next. I've already told you about the licensing agency. I will say this, to add to what I've told you, and you each have the hard copy, but to add to what I've told you, we're not limited to just, the licensing agency is not limited to just representing individuals in group licensing and trying to get things going, such as jerseys and video games and things of that sort. We're going to have a full-time executive director whose job 24 hours a day is to develop products and events for retired players. We've never had that in our history. We have never had it. We don't know the true value of all of us. We don't know, do we? Now, we know that most of us don't have value on a national level, but we also know that we do have it on a local level with our local teams. I mean, I see a great opening for regional marketing. So we can go beyond that. Let's go to the next one, the fair and reasonable. This is, let's go to the next one. And this is why Mr. Gustafson thought it was fair and reasonable, because he felt it was had been supervised by the court, extensive settlement negotiations. The court became very familiar with all the issues, and it felt that this is a case that should have been settled. It felt that and it directed that these benefits be to retired players as a whole. And it felt that there was no, the reason that it'd be difficult to determine the value of each player's right of publicity is because it's just flat out difficult. How often did they appear in the film? Were they a bit player? Were they the dominant person? There's going to be a dispute among retired players how to divide up the money. Bob Zeman, you remember when Bob Zeman, you remember when we it was before the leagues mandated how playoff money was to be distributed, and they left it up to the players. Maybe you don't remember it, but they left it up to players. It was shameful the way the guys reacted fighting over the money. The guys voted to not give the equipment manager a dime. They voted to give the coaches half a share. They voted that the only way you get a full share if you played all then 14 games. The fights over money would be embarrassing. Next, there has been a great deal of discovery already in this case. It's been going on for, as I say, 4 years. And remember, another difficulty, if you remember what Mr. Hazard told you, that every state creates its own laws, common law or statutory law. So another difficulty in monitoring how these monies would be divided was what would be their rights under each of the states. Next. And here's probably the most important thing as to why Mr. Gustafson decided that this was fair and reasonable. Judge Magnuson, the judge who will hear the case, he said, a realistic view of this matter reveals serious difficulties both with plaintiffs' claims and with their chosen vehicle for redressing their claims. Here's the sledgehammer. Certification of class is highly doubtful. And again, this court has already decided the statute of limitations is 6 years, and that severely limits the time period from which damages might apply. And the judge further observed it was unlikely that any single plaintiff's claim is so valuable as to warrant engaging in the protracted litigation that is likely to follow if this case is not resolved. I'm going to be finished in 2 seconds.
Wasn't it this judge who also called the retired players a bunch of whiny kids asking for dessert?
Yeah, I thought that
It was in the transcript, right? He actually said that.
Yeah, he said that. I thought that was, frankly, I didn't like seeing that because I don't view that as being accurate. But that doesn't mean his judicial knowledge and observation is tainted. Cool. Thank you. Mr. Gustafson decided that if the litigation continued, he saw that the players would lose, they would get nothing. And keep in mind, this has been done before with Major League Baseball. They sued and they lost. Now, the nice part about these is people have the right to opt out and bring their own claim. I hope they don't, but that is their right. And let me cut short mine and turn it over to Mike and Fred.
Boom boom